Hi everyone, I'm Catherine with Visa Harmony. Today I want to talk about the 3 major requirements for K1 or Fiance petition. Before the petitioner and foreign beneficiary can file for a K1 or Fiance petition, they both need to meet 3 major requirements. Number 1. Petitioner needs to be a U.S. citizen. Only U.S. citizens can petition fiancés. Number 2. Both the petitioner and beneficiary need to be either single or free to marry. If one or both of them were previously married, the previous marriage should have been legally terminated before filing for a petition. It can be through divorce, annulment, or through death of the former spouse for widow or widower. Note that you need to follow the laws in both the U.S. and the foreign country for the termination of marriage. In USA, there is divorce, so final divorce decree is required if applicable. In the Philippines, there is no divorce. The only way to terminate the previous marriage in the Philippines is through annulment, which can be expensive, and the processing can take months to years. For a Filipino beneficiary who was previously married, you will need to submit a copy of the annulment finality and other documents related to the annulment of marriage. Sharia divorce is only valid if the marriage was celebrated under the Sharia law as well, meaning both parties were Muslim when they got married through a Muslim ceremony. I have seen cases where the Filipino beneficiary converts to Muslim just so the Filipino beneficiary can file for Sharia divorce. This is not acceptable under the Philippine law. Please do not do this. We do not accept cases like this. You need to follow the process and file for annulment and wait until the annulment is finalized before filing for K1 or Fiance petition. Another shortcut that I have seen is that the Filipino beneficiary files for divorce in another country, then they file for K1 or Fiance petition. This is also not acceptable in the Philippines, especially if both parties to the marriage are Filipinos. Foreign divorce is only acceptable if the previous spouse of the Filipino is a foreigner and the foreign spouse filed for divorce in the foreign spouse's country. And even then, the divorce needs to be recognized in the Philippines by filing for a petition for recognition of a foreign divorce with a licensed Philippine lawyer. The third shortcut I have seen is the presumed death of the previous spouse. Filing for annulment based on presumed death is sometimes faster in the Philippines. But if the Filipino beneficiary knows that the previous spouse is still alive and filed for annulment based on presumed death, that constitutes as fraud. This is not acceptable because the U.S. Embassy does a thorough background check and investigation on cases like this. If you are seeking for U.S. immigration benefits, please follow the law. Do not do any shortcuts because even if you were able to get away with it the first time, there are a lot of steps with U.S. immigration that one day it might catch up with you. The third and final major requirement before filing for K1 or Fiance petition is that the petitioner and beneficiary need to have already met in person within the last 2 years. You need to show proofs like pictures together, plane tickets, boarding passes, or stamps in passport to show that you were at the same location or country at the same time. If it has already more than 2 years when you met each other in person, you need to find ways to meet again in person, whether it's in USA, the foreign beneficiary's country, or other location or countries before you can file for K1 or Fiance petition. In the form instructions, it listed 2 exceptions for this requirement, which are: A. The requirement to meet your fiancé in person would violate strict and long-established customs of your fiancé's foreign culture or social practice, and that any and all aspects of the traditional arrangements have been or will be in accordance with the custom or practice. This only applies to countries where arranged marriage is accepted and there is a strict requirement to not meet the fiancé before marriage. You will need to submit proofs for this. The second exception is the requirement to meet your fiancé in person would result in extreme hardship to you. These 2 exceptions are hard to prove, and I have not seen any case that K1 or Fiance petition got approved without meeting in person. Note that for K1 or Fiance petition, The petitioner and beneficiary will need to get married within 90 days after the beneficiary arrives in USA on K-1 visa. So it is important to at least meet in person to show that your relationship is genuine and it's not just for immigration benefits. Let's recap. The three major requirements to be eligible to file for K-1 or fiancé petition are as follows. Number 1, petitioner is a U.S. citizen. Number 2, petitioner and beneficiary are both single or free to marry. Number 3, petitioner and beneficiary have met in person within the last 2 years. So those are the three major requirements you need to satisfy before you can file for K-1 or fiancé petition. If you have any questions on K-1 or fiancé petition, please list them in the comment section. We have a complete guide on our website, visaharmony.com, for the requirements for the K-1 or fiancé petition, or if you need assistance to file your petition or any U.S. immigration applications, I will list our contact information below. Thank you and see you next time.